If you're facing drug-related charges, the distinction between simple possession and intent to deliver could mean the difference between a light sentence and serious legal consequences. Understanding these terms is critical, whether you're a defendant, someone supporting a loved one, or simply curious about the legal system. In this video, we'll break down the key differences between these two charges, explain how the prosecution builds its case, and share expert insights into how criminal defense attorneys approach each situation. Stick around to learn how to spot the difference and what it could mean for your case. What is simple possession? Simple possession refers to the unlawful possession of a controlled substance for personal use without any intent to distribute or sell it. This is generally seen as a lesser charge compared to distribution-related offenses, and it often carries lighter penalties, especially for first-time offenders. However, even simple possession can result in serious legal consequences depending on the drug type and the laws in your state. For example, possession of certain substances like heroin or methamphetamine may lead to significant fines or jail time. A skilled defense attorney can often negotiate for reduced penalties, especially if the defendant has no prior convictions. What is intent to deliver? Intent to deliver refers to possessing a controlled substance with the purpose of selling or distributing it to others. This charge is more severe than simple possession and can lead to harsher penalties, including long prison sentences and significant fines. Prosecutors will look for evidence that suggests the individual had plans to distribute, such as large quantities of drugs, packaging materials, or financial transactions related to drug trade activities. It's important to note that having these items alone doesn't always mean intent to deliver. Context and intent play a major role in the case's outcome. The role of quantity, a key indicator. Quantity often plays a significant role in determining whether a charge is for simple possession or intent to deliver. While possessing a small amount of drugs, such as a few grams of marijuana or cocaine, may typically indicate personal use, larger quantities can raise suspicion of trafficking or distribution. However, the key here is context. Having a larger quantity doesn't automatically mean the person intended to deliver. The defense can argue that the drugs were for personal use or that the amount was not indicative of intent. Criminal defense attorneys often examine the specifics of the case, including the type of drug and the circumstances of the arrest, to build a strong defense. Packaging and distribution materials. One of the major indicators of intent to deliver is the presence of packaging materials and distribution tools. If the drugs are found in separate baggies or contain scales, packaging tape, or other distribution-related items, prosecutors may argue that the person intended to sell or distribute the substances. Simple possession charges typically involve drugs found in a single container or bag, indicating personal use. However, if multiple baggies are found, or there is evidence suggesting the drugs were intended for resale, the charge could escalate to intent to deliver. A defense lawyer will challenge such evidence, particularly if it's circumstantial or insufficient. Behavior and context matters. How and where drugs are found can also influence whether a charge is classified as simple possession or intent to deliver. If an individual is arrested with a small amount of drugs in a private setting, like their home or car, it's more likely to be seen as possession for personal use. However, if the drugs are found near a high-traffic area or a known location for illegal transactions, prosecutors may argue that the drugs were intended for distribution. Additionally, if multiple people are involved, or if the defendant was caught engaging in behavior associated with drug sales, the prosecution may attempt to upgrade the charge to intent to deliver. The legal threshold, more than just the drug amount. While the quantity of drugs is often a key factor, it isn't the sole determinant in distinguishing simple possession from intent to deliver. Different states have varying thresholds for what constitutes possession with intent. For example, in some states, even possessing a seemingly small amount of a particular drug may trigger an intent to deliver charge if other factors are present, such as a large sum of money or distribution paraphernalia. For defense attorneys, the strategy often involves challenging the prosecution's interpretation of the facts and questioning whether the evidence truly supports an intent to distribute. The importance of evidence in intent to deliver cases. When it comes to intent to deliver, evidence plays a critical role. Direct evidence such as transactions, undercover buys, or text messages arranging sales can provide a strong case for the prosecution. In contrast, circumstantial evidence, like large amounts of cash, O-sheets, small denominations of case, multiple empty baggies, or suspicious behavior may raise suspicion, but isn't enough to prove intent to deliver beyond a reasonable doubt. A skilled criminal defense attorney will work to poke holes in the prosecution's evidence, showing that it doesn't conclusively establish the defendant's intent to distribute drugs. A solid defense may argue that the evidence simply points to personal possession. Possession with intent in different drugs. The severity of charges for intent to deliver can also depend on the type of drug involved. For example, drugs like heroin, methamphetamine, and cocaine often carry more severe penalties for intent to deliver due to their high potential for abuse and the societal risks associated with their distribution. Conversely, possession with intent to deliver marijuana may carry lighter penalties, depending on the jurisdiction, particularly in states where marijuana is legal for medicinal or recreational use. Understanding the nuances of these laws is critical, as they can affect not only the charges but the potential defense strategies employed by your attorney. Sentencing and penalties. Simple possession versus intent to deliver. The penalties for simple possession and intent to deliver are dramatically different. Simple possession, particularly for first-time offenders, often leads to probation, fines, or short-term jail sentences. For example, a first offense involving a small amount of marijuana might only result in a fine or mandatory drug counseling. On the other hand, intent to deliver charges can carry significant prison time, ranging from several years to life in some cases, especially if it involves a large quantity of drugs or a history of trafficking. Understanding these penalties is crucial when developing a defense strategy to reduce charges or penalties. Defending against simple possession charges. There are several defense strategies that a criminal defense attorney can use to challenge simple possession charges. One common defense is the claim that the individual did not knowingly possess the drugs. For example, the drugs may have been in a shared space, and the defendant had no knowledge of their presence. Another defense involves challenging the legality of the search and seizure. If law enforcement violated the defendant's constitutional rights during the arrest, evidence gathered during the search may be inadmissible in court. A strong defense can result in reduced penalties or even dismissal of the charges. Defending against intent to deliver charges. Defending against intent to deliver charges is more complex and often involves showing that the defendant had no intent to distribute the drugs. A criminal defense attorney might argue that the quantity of drugs was for personal use, not distribution, or that the drugs were intended for recreational